Chairman Cruz, Ranking Member Whitehouse, and members of the subcommittee. Thank you for the opportunity to testify concerning the grave constitutional violations inflicted as part of Arctic frost. After the 2020 election, an anti-Trump FBI agent named Tim Thibault attempted to use the Justice Department to destroy the president. Thibault's efforts led to the launch of Arctic frost. Soon after, Merrick Garland tapped Jack Smith, a hyper-aggressive prosecutor known to overstretch the meaning and intent of the law, to serve as special counsel. Smith proved himself true to form, indicting Trump for allegedly violating a statute enacted in the aftermath of Enron, based in part on a theory of criminal liability the Supreme Court would later hold invalid. The Supreme Court would later also halt Smith's efforts to prosecute Trump for actions that fell within the president's official duties. Beyond being a partisan in his own right, Smith stacked his team with partisan Democrats, such as J.P. Cooney and Ray Holser. Cooney and Holser served as Smith's top deputies, and in them we see the clear double standard and political bias that permeated the DOJ and FBI. Before joining Smith's team, Cooney crafted an outrageous sentencing memorandum that sought to send Trump advisor Roger Stone to prison for 7 to 9 years. Cooney's sentencing recommendations were so unhinged that the then Attorney General William Barr intervened. Cooney responded by spreading unfounded rumors that Barr and the acting U.S. Attorney were being improperly political, with media leaks furthering that narrative, eventually leading to an Inspector General investigation. The IG cleared the Trump administration, but chastised Cooney. Holser, for his part, demonstrated his partisan proclivities when he headed up the public integrity section and refused the FBI's request to open an investigation into the Clinton Foundation. But Holser's partisan protection racket went further when he withheld a 6-page timeline of the Clinton Foundation investigation from the then U.S. Attorney operating out of Little Rocket. Instead, he provided an abbreviated 2-page summary that omitted all references to interference from the DOJ and the FBI leadership. In contrast, when the target was Trump, Holser, along with Cooney, drafted a memorandum to justify subpoenaing the toll records of about a dozen members of Congress, notwithstanding internal email discussions acknowledging a clear speech or debate clause problem. They then hid the details of those subpoenas using the prohibited access functionality of Sentinel, which ghosted the FBI records. As this committee well knows, because many of you were victims, Smith approved the subpoenas and obtained the toll records of Senators Blackburn, Graham, Hagerty, Hawley, Loomis, Johnson, Kennedy, Scott, Sullivan, and Tuberville. Only Senator Cruz escaped the invasion into his privacy and the violation of the speech or debate clause because his cell phone provider questioned the subpoena. From this subcommittee's January 7th hearing, you also know that Smith's team sought a non-disclosure order from Chief Judge James Boasberg, apparently without informing him that the targets were members of Congress. I say apparently because Chairman Cruz's request for the non-disclosure application to be unsealed has been ignored. Yet again, we see the double standard and the weaponization. Judge Boasberg has still failed to order Smith and his prosecutors to show cause for why they should not be held in contempt for concealing the members of Congress were the ones who were being targeted. This fact should not be ignored if you are to believe Smith and the administrative office of the court's testimony that Judge Boasberg did not know that your identities were involved. It makes absolutely no sense that Boasberg would not enter a show cause order to hold Smith accountable for violating your rights, given Judge Boasberg's nearly year-long crusade to hold a member of the Trump administration in contempt. We now know that Smith violated the speech or debate clause, rubber-stamped by Judge Boasberg. He went further, and he subpoenaed the toll records of Kevin McCarthy, former Speaker, and Chairman Jim Jordan, again under cover of a non-disclosure order. Add to that the hundreds more served on individual Republicans, including Trump's attorneys, Republican organizations such as Charlie Kirk's Turning Point USA. And they didn't seek merely toll records, but also bank records, which revealed the donor base. The breadth of these constitutional intrusions is unprecedented. But to recap, Smith unconstitutionally was appointed special counsel in violation of the Appointments Clause. The subpoenas of the toll records violated the speech or debate clause. The vast and unjustified subpoenas to Republicans and the organizations that were connected to them violated the First Amendment associational rights. The targeting of Trump's attorneys implicates the Sixth Amendment right to counsel. And using prohibited access to bury records is a huge due process violation that raises potential violations of Brady. Smith and his team must be held accountable. Thank you.